Well, a big win for school choice and religious freedom. The Supreme Court has ruled that parents can use state funds to send their children to religious schools.
The decision is expected to have an impact on tuition programs nationwide. Charlene Aaron has the details.
The case challenged a Maine law prohibiting parents from using state aid to send their children to faith-based schools. The state offered tuition payments for students to attend private schools in areas where public schools are not available, but faith-based schools did not qualify. The justices called that discrimination. In their 6-3 ruling, the justices said Maine could not exclude religious schools from the program. Chief Justice John Roberts writing in the majority opinion, a neutral benefit program that gives public funds to religious organizations through the independent choices of the recipients does not violate the Constitution's Establishment Clause. And Maine's non-sectarian requirement violates the Free Exercise Clause of the First Amendment because the program operates to identify and exclude otherwise eligible schools on the basis of their religious exercise. On CBN's Faith Nation, Leah Patterson, counsel for First Liberty Institute, said the ruling could allow parents outside Maine to use state funds to send their kids to private religious schools.
What the Supreme Court did today is reaffirm what it's already decided, that when a state creates a school choice program, it cannot exclude religious options.
Justices on the court's liberal wing wrote strong dissents to the opinion. Justice Breyer saying the court is focused too much on the Free Exercise Clause and not enough on the Establishment Clause. But the strongest dissent came from Justice Sotomayor, who wrote, "In 2017, I feared that the court was leading us to a place where separation of church and state is a constitutional slogan, not a constitutional commitment. Today, the court leads us to a place where separation of church and state becomes a constitutional violation." To that, Patterson says,
I'll just point out that the words separation of church and state are nowhere contained in the U.S. Constitution. What it does contain is a commitment that the government not discriminate against religious exercise.
The High Court still has 13 rulings to release, including the high school football coach fired for praying after games and the abortion case that could overturn Roe v. Wade. All decisions are expected to be handed down by the end of next week. Charlene Aaron, CBN News.
Well, and expect an outcry from the left over this decision because the impact nationwide is going to be tremendous. It's going to mean that states can now give vouchers to parents, and the parent gets to choose what school their child goes to. These kinds of voucher programs have always been objected to that, well, we can't have vouchers that go to Christian schools or to religious schools. That would violate the separation of church and state. So now the Supreme Court has come down definitively saying, well, if you exclude religious schools from a voucher program, that means you're prohibiting the free exercise of religion. So it's a wonderful decision. But what's the ultimate end game? The ultimate end game, I think, has been to let's create a public school system that the left can control, not the parents control, but we will force and indoctrinate your child, and it may be views that you think are wrong, but that doesn't matter. The state gets to raise your children. If the voucher program takes over, it puts power back where it should be, in the hands of parents.